Before we get to our enrollment report, I'd like to make a brief statement. I'm going to briefly address a matter that the WTA has raised both publicly and again tonight, one that is both factually incorrect and a gross distortion of a contractual responsibility of the Board of Education. While I'm reluctant to dignify this with a reaction, I'm compelled to do so because the implication is that both the Board of Education and I are somehow complicit in wasting taxpayer resources. This false accusation cannot be allowed to stand. The WTA has said the following: in addition to his salary, the board has approved for him an interest-free loan of up to $25,000 to defend himself in a lawsuit. This is false. The Board of Education has never loaned me money to defend myself in a lawsuit. Instead, the board has directly paid legal fees to a firm in connection to a lawsuit filed against me and other professionals from my former school district. These payments have been made by resolution of the Williamsville Central School District Board in accordance with both district policy and my employment contract. As noted by our school district law firm, the board had the discretion and authority to conclude that it had the duty to defend and indemnify you. It should also be made plain that responsibility for any legal fees ordered by the court regarding this frivolous claim will be returned to the Williamsville Central School District. It should also be noted that the board approved this resolution in public, as it must, more than 2 years ago. Yet the WTA has been silent on this until just recently. So why would a school district make payments for a legal defense for me based on something related to a prior district and not in Williamsville? Because the allegations made against me by this individual that I did not provide a neutral reference for a prospective employer of the individual occurred not while I was in the Byron Burgeon Central School District, but during my conduct as a superintendent of the Williamsville Central School District. This included contact between myself and the State Education Department regarding my former district and this specific situation, which was alleged in the suit. There is nothing illegal, inappropriate, or untoward about this indemnification. Superintendents and other administrators are commonly named in suits like this and indemnified as necessary. Finally, it should be understood that the plaintiff in this case recently admitted during his deposition facts regarding my involvement that were contrary to his complaint. Thus, my legal representatives have moved for removal of my name in this frivolous suit. It is, in sum, a false accusation from this individual. Unfortunately, it appears the WTA has again used this bogus story to attack my credibility and that of this Board of Education. So where does that leave us? The board has twice met with union leaders and voted not to conduct an investigation. I have met on 2 occasions with members of the Williamsville Administrators Association over the past 3 weeks to move business of the district forward. Meetings, I believe, have been productive. So I will once again say it is time for us to move forward. And I urge Mrs. Light and other WTA leaders to end this campaign of personal vilification. The reasonable expectation that we work together, and I stand ready to do so. On behalf of our students, staff, and community members, I sincerely hope you will reconsider your current posture and return to productive dialogue that focuses the conversations on where they should be, our students. Thank you.